Today we're here to talk about what a client should expect when they're seeking legal help about a human rights issue. And I'm here today with Wade Poziomka and Kathryn who are experts in human rights law. Now, Wade, let's jump right into it. How do I know if what I've experienced is actually a human rights problem?
It's a very good question and an important one. A lot of employees or people who use services think that general allegations of unfairness, so something unfair happened to me, I got a poor work performance evaluation, or I wasn't chosen for this assignment over my colleague, they think those are human rights issues. And that's not the case. Human rights issues are that negative treatment that happens for a code-protected ground. Code-protected grounds are disability, age, religion, marital status, family status, sexual orientation. So it's when something negative happens in the workplace.
Is that the Human Rights Code?
That's the Human Rights Code. So it's when something negative happens in the workplace that's connected to a ground, that's when it becomes a human rights issue. If it's not connected to a ground, there's other areas of employment law that can likely address that, but it isn't a human rights issue. The other thing that applicants should know, and applicants are someone who file an application with the Human Rights Tribunal. Service providers, housing providers, employers, those are typically your respondents. So applicants should be aware that there's two different types of discrimination. There's direct discrimination. An example of that would be, Joe, your employment's terminated because you have a disability. That would be direct discrimination. Adverse effect discrimination is when you have a policy that applies to everybody. So for example, an employer who has a policy that says if you miss 10 work days, you're fired. Now somebody who has a disability misses 15 work days because of that disability. And so they would be caught under that policy that applies to everybody, but they're being treated differently because of their disability. That would be adverse effect discrimination.
Okay, Kathryn, can we get the respondent's perspective on that?
Sure. So there are human rights issues that operate every day in any type of organization, whether you're an employer, a service provider, an accommodation provider, they will bounce along day to day. But typically, when a new client comes in, they know it's a human rights issue because it says so on whatever document they've received. So whether that be a human rights tribunal application that's been filed by an applicant, as Wade has just described, a demand letter, so you've got a letter from a lawyer or a letter from just the individual saying, I'm telling you I believe you've breached my human rights, or a statement of claim from the court that relies on a breach of the Human Rights Code. So it's a much simpler answer for respondents or employers. Usually they know because someone's telling them it's the case.
Okay, well, I'm an applicant. I believe that I may have suffered an injustice, discrimination. As an applicant, what should you bring with you when you've made that appointment with the lawyer?
I would say bring everything related to the situation with you. That could be a termination letter if you've been fired, disciplinary letters, work performance evaluations, any emails where you're requesting accommodation from the employer or the service provider. That's all very important to bring with you. The lawyer is going to be looking to get an idea of what happened in the workplace and how is it connected to a human rights ground. So bring everything with you, and the lawyer will tell you what's relevant and what's not relevant when you're there sitting with him or her.
Okay. Well, if I'm a respondent, owner of a business or an employer, and I've just been served with paper saying that I've committed an offense under the Human Rights Code, what should I bring with me when I make that appointment with the lawyer?
So as Wade said, bringing more rather than less is great. But in particular, you want to make sure you bring a copy of the document. So whether that be the letter, the human rights application, or the statement of claim. You want to make sure you bring with you any copies of the documents that you've been sending back and forth. So if you've already been corresponding with the individual on the matter, you want to make sure you bring whatever copies of those documents, as well as any documents that relate to the allegations. So to take Wade's example of a poor performance review that you say is based on your disability, you would want to bring a copy of the employee's personnel file, the performance assessment, any documents that back up the performance assessment. So anything that could potentially help the lawyer understand your side of the story. It's also helpful to bring a brief outline that you've written in terms of your response. That's not to say that's going to make its way into the response filed by the lawyer, but it's helpful for the lawyer to understand in your words what you say happened in response to this application. An org chart or something similar is also of value so that the lawyer can understand who are the people within your organization, where do they fit within the structure, and what their titles are. Because as your conversation goes on, you're going to be mentioning Joe, Jack, Jeff, John, etc. And the lawyer may or may not be able to keep up with who all those people are and what they do.
Okay, let's step into that conversation for a moment. I've brought all my paper with me, and you may have had a chance to review it. What type of questions should I expect the lawyer to ask of me as the respondent in a human rights matter?
I think it's really important for people to remember that just because you're in that first meeting doesn't mean you're tied to that lawyer permanently. So you need to ask the lawyer questions just as much as the lawyer needs to ask you questions. And I think that the first part of the meeting should really be you asking the lawyer questions. It is totally acceptable and important for you to be comfortable with the person that you've retained. So make sure you're asking questions that you want answers to. What is this lawyer's experience? How can you expect to be charged for this work? How long is it going to take? Have they done this before? Make sure you're comfortable with the person that you're intending to retain, because just because you've had one meeting or just because you're sitting at the beginning of one meeting does not mean that your options are over and you're now stuck with this person. I promise you, as Wade will back me up, you will spend a lot of time with this lawyer. So make sure you're comfortable with them and you want to work with them. I think that's really important.
Okay, well, put the shoe on the other foot. I'm the client, the applicant in this situation. I feel that I've suffered suffered discrimination, and I've crossed that burning bridge. I've made an appointment with the lawyer's office. What type of questions should I expect from the lawyer when I go to that appointment?
So you can expect questions around the ground you're alleging. So for example, if you're saying that you were treated differently because of a disability, the lawyer is going to ask you questions around what your disability is, what are the functional limitations from that disability, and then what happened in the workplace that's negative. Were you terminated? Was it a poor work performance evaluation? So you're going to be asked about that. And then finally, the lawyer is going to challenge you on connecting those. So what evidence do you have that suggests the negative treatment was because of the disability? And that's important because that's how you win a human rights application. So you can expect those types of questions. A lot of questions around the background of the workplace, like Kathryn's already mentioned, your job duties. So just be prepared to discuss anything, but in particular how the code ground is connected to the negative treatment you've received.
Okay, Kathryn, we're still in that initial interview. What are some of the important things to make sure to keep in mind?
At the risk of being corny, the most important thing is to tell the truth and all of the truth. A lot of people come into meetings with their lawyers and they don't want to tell them all the bad news and they only want to tell them a certain amount. And that's really dangerous. It's really dangerous for two reasons. One, the lawyer is there to represent you, not make decisions about what you did or make you feel badly about yourself. But importantly, the facts that you think might not be helpful might be the key to the answer to your defense. And the lawyer is paid to know that, and so it's important that you tell them all the information. And then secondly, it's very valuable to know the bad facts at the beginning of a file, because then you can craft the story and the theory of the case on the basis of all of the facts, and you can find a way to fit the bad fact in. If the bad fact doesn't come out until 3, 6, 9, 12 months down the road, it becomes very difficult to deal with that bad fact because it may contradict part of the story or the theory of the case. So really just lay it all on the table.
Okay. If I'm somebody who has been discriminated against, or I've just received a really bad performance review and I suspect a human rights issue, it could be very upsetting. What are the important things for the client to think about when going to see a lawyer?
So I would echo what Kathryn said. There's nothing worse for a lawyer than having facts come out in the hearing. You want to know right away what the facts you're dealing with are. So be honest with your lawyer, and You know, a lot of these meetings can be emotional, so clients will come in and they'll be upset, and that's fine. Take your time and make sure you tell the lawyer everything that you think is relevant and pertinent to your situation.
Okay. And back to you, Kathryn. At the conclusion of the meeting, what should a client expect to happen?
So a client should expect to know what's going to happen next. So they should be aware of what timelines things are going to happen in, what is expected of them. So if I'm giving my client a big list of documents to take with them, when do I want those documents back? How long am I expecting that the response to be turned around in? What are the next steps in the file? You should have a clear understanding of what the next runway is.
And Wade, what should the applicant expect at the conclusion of the meeting?
I think what the next steps are and when they'll happen. So you should, if you're going to have that lawyer represent you, there should be a retainer agreement in place. You should know how the lawyer is going to get paid. I think it's important for you also to know what you can expect at the end of the day, at the end of that process. So if you win, what's a remedy you can expect? And the lawyer is not going to be able to give you a definite answer, but usually they can give you a range in the initial meeting. And then what's the lawyer's obligations and what are yours? So when do you have to have documents to them by, like Kathryn's mentioned, and when are they going to have the application drafted for you to review before it's filed with the tribunal? So basically there should be no questions left from that first meeting.
Okay. Well, I wish we had more time to talk about many of these issues, but thank you for taking some of the mystery out of human rights matters, and thank you for tuning in.